Hello and welcome to The Big Picture. The Future of Land Acquisition Act passed in 2013, amended in the Lok Sabha last session and now before a select committee has become uncertain. Even as the committee has sought more time to come out with its report, the ordinance with the amendments continues to be in force after it was re-promulgated in May this year for the third time. Meanwhile, at a meeting of the chief ministers convened by the Niti Aayog last week, it was evident that the states were divided on the proposed amendments, which had led to a suggestion by the finance minister that some states would like to pass their own laws. He also hinted that these state governments want to pass laws in tune with the amendments proposed by the centre by the Land Acquisition Bill 2015. While the Select Committee is still looking at the bill, this suggestion is clearly an indication that the centre is keen to push the law through the states where its party governments are in power. Now, what are the legalities in states passing their own laws? What would be the impact of it? What problems may arise if states decide to do it? And is it the best way out considering the logjam this issue has got into? We will discuss all this today with Hanan Mollah, General Secretary All India Kisan Sabha and a former CPIM MP, Chaudhary, President Bhartiya Krishak Samaj, Sudhir Krishna, former Secretary Urban Development, Government of India, Muhammad Khan, advocate and former OSD to Rural Development Minister Jairam Ramesh, with whom he has co-authored a book on making of the Land Acquisition Law 2013, and Nitin Sethi, Associate Editor, Business Standard. Welcome to all of you. Krishan Chaudhary जी, आप बीजेपी के साथ जुड़े हुए हैं आजकल. आपको you think that this proposal which has come out at the Niti Aayog meeting that the states may have to some of the states are at least interested in passing their own laws. Is it some kind of an attempt to overcome the problems which this law has got into, or these amendments have got into?
Land is the state subject. It's okay, but there should be some check and balance from the central government. Otherwise, you will see there will be more and more corruption will be there in the land acquisition. Still, the country has a lot of examples that land use conversion, it's a most corrupt practices adopted by the state government, and no free hand should be given to the states in the subject, because land is the main issue of the farming community, and it should not.
So you're not in favor of no. States enacting their own laws in this matter?
No free hand should be given, Nikamji, because there should be check and balance. There should be minimum scale, minimum criteria should be there, especially for the consent and the compensation clause should be finalized by the government of India. Minimum scale should be finalized. See what's happening in the 2013. How the states are using that act. Farmers getting the compensation only the 2 times in Rajasthan and Haryana. All political parties are not raising this issue. Why the political parties are not accepting the reality? They promise that 4 times compensation is there, but there is no 4 times compensation. The states are giving 2 times only. In the corridor also, in the Haryana government also, they say as per the law of the 2013, only 2 times compensation. Up to the 8 kilometer, it's clearly mentioned that up to 8 kilometers, it's a double. After up to 15 kilometers, after 25 kilometers from a city or a town, then it will come the 4 times, and land acquired everywhere in the country is within the 8 to 10 kilometers only, so not after 25.
Okay, so you're saying that if states are allowed to pass their own laws, all these kind of things will happen. So
corruption will increase.
Corruption will increase. Mr. Mollah?
This attempt by the central government now asking the states to make their own law, that when they found it is more difficult.
Is this an attempt of the central government, or you think that the states are demanding this?
No.
Because what we are told is the states are demanding.
I am telling it that the government, when found it is very difficult, half of the chief ministers didn't attend, found it is difficult, then government is trying to find an escape route. It is an escape route to run away. But we will not allow the government to run away, because 1894 Act, it was a central act. 2013 Act is a central act. And they should not be allowed to run away from the central act, because land, though it is state subject, there should be, as Girish said, that they should not be allowed to free hand for doing corruption. Some checks and balance. So Central Act, they cannot do it. Because if there is center and state, two acts are there, Constitution says in the case of conflict, central law will prevail. First. Yes. Secondly, if a central want to make a law for the state, they will have give a model. That they can give a model that in this model you can make law. That is not there. So they are talking just to hooding the people, to make the people fool, because now they are in mess, they cannot pass it, so they want to run away, they want an escape route.
Okay. But yes. State chief minister is asking, not one or two, but about a dozen chief ministers are asking that free hand should be given and the states should frame their own act. But it's not good.
It's not good. It
should not be.
But the demand is there, Mr. Sudhir Krishna. Now, what are the technicalities and legalities here? And you think that the states should have their own law? And even till the 2013 law came into place, what was the picture?
The position is that the land acquisition is a state subject, no doubt.
Yes.
But acquisition of act is in concurrent list of the 7th schedule of the Constitution. Right. And therefore, the central parliament gets authority to make law, and when the parliament makes a law, the state's law becomes subservient to it. And parliament, when it makes a law, and moreover the law is made in consultation with the states, and therefore legally speaking, constitutionally speaking, the federal parliament and the central government, they are quite competent to proceed with the central legislation. This is the technical position. And this was the position even under the Government of India Act of 1935 and before that also, the 1891 Land Acquisition Act was there. It was under that domain it was working. But the practical point when we go for implementation, it is true that this Act 2013 Act had some provisions which made the states nervous about the whole process and it made the whole thing so complicated that while it was looking very good from one perspective, in implementation, everybody felt those...
Which were this?
Like the social impact assessment, the popular consultation processes and so on. These were made so very complicated that the purpose of... See, the other problem is that we have lost track or we have lost confidence in the master town planning. See, the land has to be used as per a master plan. And once a master plan is notified, everybody has to follow that. And the farmer cannot... Suppose the land is declared as a area, as an industrial zone. Then the landowner is obliged to give it up for the industrial purpose. But here and there in bits and pieces lands are acquired for different purposes. There is a suspicion in the mind of the farmer, and there are umpteen cases. I mean, Karnataka is a classic example where so many cases have gone to court, and people, officers and ministers and ex-ministers are behind bars in terms of land being acquired and then notified and denotified. So all those things are there. So well, to sum up, when technically speaking, central government is empowered to make the law. But the practical problem is that states are, as things are, and there is history also. History cannot be, wished away. 1891 Act has stood the test of time for over 100 years. There are problems in that implementation of the Act. Let us remove those, problems and make the central law good. So now, having covered so much ground with history of a central law behind us, it may be worthwhile continuing with the central law but duly modified to take care of a state's concerns.
Okay. Mohammad Khan, you think that, some of the people, even the 2013 Act, which you played a significant role in that, do you see that, there are certain provisions there which requires amendments, and you think that, that those amendments would be necessary, and if they are done in a proper manner, that itself will be enough, and the states need not, enact their own laws?
Well, two things, sir. As my co-panelists have already pointed out, it is very correct that acquisition is a concurrent subject, which means that once there's a central law, then the state law becomes redundant.
Does it become redundant or subservient?
Redundant, because as Mollah Sahab
states can also have their laws.
No, I'll explain. Mollah Sahab pointed it out very correctly when he said under Article 254 of the Constitution, any conflict renders the state law repugnant, which means that it ceases to exist.
One second.
But if I must clarify here, under Article 254(2), if the state law receives the permission of the President, then it can become operational. However, to prevent situations like that from occurring, the 2013 law has an additional clause. It has a clause 107, which says that if a state still passes a law which tries to reduce the benefits and entitlements given under the new law, then that law will be in violation of the 2013 Act. So even if the law becomes a valid statute by virtue of the approval of the President, it will still be in contravention of the 2013 Act.
A State Act. You're talking of a State Act.
I'm talking of the State Act being in contravention of the 2013 Central Act.
Right.
Then it can be challenged before a judicial body of any kind, either the High Court or the Supreme Court. As far as giving the power of acquisition to states is concerned, I think it's a very big step, because acquisition is an inherent aspect of sovereignty. For example, your right to tax, your right to carry out foreign relations, your right to defend the territory of India, these are all sovereign acts. You can't delegate them to a state government. Eminent domain, which is the power to take over land, is also inherently a sovereign function. If we were to give it away to the states indiscriminately, it would result in a very huge disproportionate balance being created. So therefore, I think the move is badly thought out for a variety of reasons.
Okay, the move is... Nitin, what is the idea, what is the motive behind this move? According to you, what is the motive behind this move? Because we are told that, the state chief ministers are very keen to pass these laws because, it is coming in the entire, the kind of uncertainty over these, the ordinance and the amendments is coming in the way of states being able to get investors coming in and investing in their states.
Well, I think, Girish, there's a lot of rhetoric which does not match with the facts. Now, to give you some facts, in the last year or so that the BJP NDA government has been there, there have been at least more than 100 notifications of land acquisition under various laws which have been going on regardless of what's happened with the ordinance and the politics around it. We've not heard one case from any state saying that this particular acquisition was not done simply because there was a confusion about 2013 and the ordinance in place. Now, if you look at it in perspective, even under the 2013 law and the 2014 law, there are several kinds of acquisitions which were already allowed and continue to be allowed forcefully, say under the Coal Bearings Act, under the National Highways Act. These can already be done under even 2013, and they have been done in the last 1 year as well. Now, here I think BJP and NDA have got themselves stuck in a position where they can't step down from their own rhetoric, and they're trying to find a way out, which, as Mohammed, and I think I agree with Mohammed on that, it's more convoluted than the original idea of the ordinance, which they thought they could ram through. Again, now, as if one was to take forward Mohammed's argument and others' argument that your panelists have made, if now the government wanted to permit the states to bring out their own laws, they would have to again bring an amendment to the 2013 law, even if they took away with this. That amendment would again be brought to the Rajya Sabha and the Lok Sabha and would get stuck in the same situation as the current one. So the government's kind of locked itself into its rhetoric is the feeling I get out of this.
Okay, that's interesting. Mr. Krishna?
Well, I think that
the kind of legal problems which we encountered.
Legal issue, as I said, that now what the laws which are allowed to remain concurrently are central laws basically. And earlier on, the state laws were there, like Industrial Development Act, which allowed...
No, but what Nitin is, that several acquisitions are happening even after 2013 and after the ordinance.
Yes, several acquisitions are happening and...
more than 100. More than 100 notifications in 1 year.
Yes, many notifications have happened and these maybe the court of law may settle the matter. But no, we have to look for the future. That what has to be done is the central law has to be there now, because as I said, there is a history of central law of 1891, which has stood the test of time. There are implementation problems which are resolvable, and we can, with the modern technology being available, with all the information technology available, we can resolve. And there are irritants in the present law which made the states vary, because ultimately the development is the baby of the state primarily.
Absolutely. No, let me, Mohammed, these irritants in the 2013 law, that is what we are talking about, and that's what we are told is the basic reason behind the 2015 bill which is pending there.
Frankly,
that these irritants had to be taken out. Several chief ministers, even Congress chief ministers, had complained about these irritants, and something needs to be done about it. Don't you agree? Or you think that 2013 law is a perfect law?
Well, we vehemently disagree because the law that you see before you, the 2013 law, was the product of sustained consultation carried out over a period of 3 years. In fact, the law that you see before you represents a grand compromise. In fact, we put in a far greater number of safeguards initially, and compensation was originally 6 times, and 3 times we reduced it to 4 and 2. There was a Chief Secretary's Committee in addition to the social impact assessment that would take place. We removed that completely. In fact, agar aap social impact assessment ko dekhein, it is a time-bound process. It requires 6 months. If it's not done within 6 months, the report lapses. I don't understand people's concerns when they say that the process will take 4 years. By definition, by statutory boundaries, it cannot take 4 years. People say that the process of seeking consent is very difficult. Yes, it is. But the thing is, we believe consent is a necessary prerequisite before you snatch somebody's land away. That is something that cannot be debated. If you feel that consent is an irritable factor, then that is something that is fundamentally one of the pillars of this law, and that can't be done away with.
Okay. Yes, Mr. I'll come to you.
I can only say, sir, that, I mean...
consent. You're talking of consent.
On consent part, I am saying that. Consent of whom? You see, the point is that we have taken a wrong route. I must say that with certain experience of handling the things behind. I was okay. I mean, one can always go along with the trend. People have said that consent is desirable. So one can keep quiet. But let me say that what we have lost track is plan development. We have not notified master plan for the area. And for a particular piece of land, we want to take consent or we want to impose our will. There is we have put a choice which it is like open and shut case. Either take government's will that this land will be acquired for setting up an industry, or take people's consent to say, no, this is not the right land to acquire, you go somewhere else. Now, the right way would have been to make a master plan for the area, which is notified after popular consultation. A complete process is there. That process can be reviewed also. I'm not saying it is and then it is world over that is happening. And in that process, you proceed with the land acquisition, where further consent of the individual, Gram Sabha and all that is not required. I would put it that way. That is according to me, that is a practical and implementable model.
Does what you're saying, publishing a survey of the area and a master plan, that is exactly one of the things that the social impact assessment study is. In fact,
Mohammed, are you saying that social impact assessment will include some kind of creating a master plan and putting it before the people and saying this is what we plan? We are not just snatching away some 10 acres of land.
Absolutely. Sir's colleagues in the Ministry of Rural Development, Sir's colleagues in the Ministry of the Rural Development at that point of time in the Department of Land Resources expressly helped us design the social impact assessment process in such a way so that these records, etc., these land management plans, all of these plans that the state government is required to prepare are made a part of the social impact assessment. It is done to fulfill the lacunae of the state government in that part itself. In fact, if you look at the 6 questions, one of the things that it addresses is a master plan and a displacement plan. So I don't see where the debate entirely occurs. I, in fact, get very worried when people talk about the inordinate delay that it will cause, because it shows that they haven't read the bill in its entirety.
Okay. Yes, Mr. Chaudhary.
Nikamji, for a peaceful development and for long-term policies, yes, we should go for development. But I think that the ways the National Land Use Development Authority should be framed first, and that should be seen that this area will be for agriculture in at district level. This area will use as agriculture. It's a reserve. It's for industrial. It's for commercial. We should make our own plan. I agree, Krishna. That and ways on the developed world also we have seen that without authority, without framing authority, it's not possible for peaceful. We can go in Madhya Pradesh here, Bihar here, Odisha here. It's not the proper way of development. We should make our mind fix that, yes, we go ahead to make the productivity best in the...
Okay, I think I got your point.
Only way is the National Land Use Development Authority to be framed, and there should be a full responsibility of that authority that land will be used as per their plan.
We can't do that, no, sir. That's the problem. The reason we can't do that is because of what you rightfully said at the beginning, that land is a state subject. We tried.
But it's under concurrent. It's a concurrent list.
Acquisition is under concurrent list. Land, as you correctly
pointed out, but center can suggest. The planning can be done at the national level. Policy should be framed.
They did. They in fact suggested a national land titling bill, which is available on the ministry's website. They suggested a land records modernization program. The problem is states have no incentive to comply with it. Your suggestion is actually the solution to all the problems that are currently there. But there is no means to enforce it.
Okay. Yes, Mr. Mollah. I'll come to you, Nitin. Yes, Mr. Mollah.
The question is, for several years we are listening about the national land use policy. It should be national land use policy should be there. Then it will be flexibility will be there, how it will be implemented, consultation from center, state and others should be there. But this voice of this bureaucrat and corporate, we are here. I totally opposed to this voice of this bureaucracy and this corporate.
Why are you opposed?
Because you know, they all talk of right to property. Everybody's property has a right, but farmers' property has no right. Anybody can and take it. It's a loot ka maal hai.
Let me
Farmers' right
I
is
have one
totally
experience of my own. Land were acquired in 1964 and the compensation they are giving in 2012 and the price of 64. It's all due to corruption in bureaucracy.
Okay, one second.
I have a complete document of that land in Gajewala itself.
Mr. Chaudhary will not get into the personal problems.
Corruption.
Nitin,
as Mollah has
Nitin,
raised.
you wanted to come in.
See, I think our panelists are making some relevant points, but there's a way to go about it. This government, when it came in, and the Prime Minister spoke a lot about competitive federalism. Now, if it was wanting to bring in reforms in the land sector, it would have perhaps said, let's see competitive federalism on the issue of who brings land reforms and land records to a better state. There has been a start made. It could have been done. The documentation was there. That process is not taken forward. Now, competitive federalism at this stage, when you come back and suddenly say, oh, states want their own thing, we'll let them do their own thing. It makes you ask a larger question. What is the larger perspective of this government on the social sector, on the sense of social development that the country sees? Does it have no vision of how the states would grow? You can easily see if states had their own laws, the level of development and the level of industrial growth you'll see in different states would be very different. Where will you try to bring them on parity? Now, these are issues on which the center must grapple. It must not let go and say, let the states do whatever. Then what is the role of the center left in this entire conversation? And that, I think, is what BJP and NDA and its think tanks like Niti Aayog must mull. So if the Niti Aayog has brought out the idea of saying, let's look at other models than acquisition of land, I think the government should be spending a real amount of time discussing that instead of saying we'll regurgitate existing ideas and somehow get them passed through the legislature. I think that's a deal done.
I think
it's very unfair.
No, I think you have a point there. Yes, Mr. Krishna.
I would say that the master plan which has to be prepared under town and country planning law, not under the Land Acquisition Act. And the Land Acquisition Bill was...
No, but it is not just town and country planning act will also include the rural areas?
Yes. Okay. I said country planning, town and country planning. That is by the definition. Right. And there are urban and regional development planning guidelines, URDPFI guidelines notified recently. I mean, but what happened that Ministry of Rural Development only, everybody has a vision. So they have a vision about farmer, that is all right. But planned development of the country, that is a different vision altogether. Unfortunately, the ministry could not take note of.
Right, but the problem now is this, that, all this is fine. All these things on that, future planning and all these things are fine. But here we are faced with a situation where the parliament is, right now, there is a select committee which is looking at the bill. There is also a keenness on the part of the government to get through with this as soon as possible. So in these circumstances, if the states are allowed to formulate their own laws, what would be the problem?
Well, sir, I'll answer your question in the following way. I don't think there would be a problem if they increase the benefits. For example, if states want to pay...
say 6 times more.
The very first panelist, my co-panelist, very rightly pointed out that when states are left to their own discretion, they tend to abuse the law. He gave the example of Rajasthan, where when the state was given a choice of keeping the compensation between 2 and 4 times, they set it in such a manner that if you're in a very remote area, then you'll get 4 times, but otherwise you'll get somewhere between 2 and 4. That is what states tend to do. They tend to choose a convenient via media. That is the problem. If states want to increase it to 3 times and 6 times, if states want to increase consent and social impact assessment procedures, by all means they should go ahead and do it. In fact, the law encourages that. We want that is competitive federalism in its truest sense.
No, but sorry to intervene, but the point is that the amendments which have been proposed, which is there in the ordinance actually, the social impact assessment has been given up for certain.
You're right.
you think that, there some kind of a compromise can be worked out on this, but because everybody, I'm sure all of you agree that there needs to be a new law. 1894 law is not, cannot be 2013 law is there, but even everybody agrees that even in the 2013 law, there are some lacunae which needs to be plugged.
I actually agree with Nitin on this, because he hit the nail on the head when he said there are two debates taking place here. One is with regard to general land law reform, and I think the gentleman from the Ministry of Urban Development very rightly put that, look, we have existing state laws and you need to satisfy certain procedures under them. That is correct, but there is a lack of uniformity when it comes to implementing those from state to state.
That's the point.
That is one thing. And but the second thing is that acquisition itself, I feel that states should try and implement the law as it existed in 2013. It is my personal belief that the 2013 law is complete and deserves a fair chance. The problem is that in June of last year itself, as soon as the government came to power, it called a meeting of state secretaries and said, what are the problems with the law? So there had been absolutely
there was not enough time
to
but Mr. Hanan Mollah, the question is now this, that whether this, the kind of changes which are being envisaged both by the government and the opposition parties, there needs to be some kind of a compromise. You think there can be a compromise?
This government, what the government is placing, there is no scope for compromise. There are 652 memorandum came to the committee. 652. Only 2, the FICCI and SOCHM, supporting this bill, and other 650 are opposing it. This is the situation of reality. You cannot ignore the reality. In committee even, they listen to the people in Delhi. They fail to go to the villages and talk to the farmers. Tomorrow there will be a public hearing in here in Muktadhara. 200 farmers are coming. We invited that JFC member. You come and listen. You have to listen to the leader. What the farmers are saying. You listen to them and then you formulate your opinion. So that let us see. Because we cannot think the government's attitude is totally defined, totally bulldozing. That is the attitude. This bulldozing attitude, it will be never accepted by the farmers.
Mr. Chaudhary, very quickly, you think that the states should be given a chance to work out its own laws?
No, free hand should not be given, but there should be a compromise should be there in the all political party. There should be open discussion should be there. And JPC is working on that ground. And there should be a common law for all the states.
Okay. I think on that note, we need to end. The fact is that if we will have to wait and see what the select committee report will be finally. But there seems to be keenness to get over this problem as soon as possible. But as all my panelists have pointed out, there needs to be a little more patience in dealing with these issues. And hopefully that patience will be, we'll see that patience from the government also to see that a proper law is finally implemented. Thanks to all my guests. Please keep watching. We'll come back with another issue, the big picture, same time tomorrow.